Good morning, friends. Welcome back to the next concept, that is the classification of labor legislation. So, we can't put a single labor act which should be governed by all the areas in an organization. Suppose if you have in an organization, if you see, say, recruitment will be there, wages will be there, disputes and grievances will be there. So we cannot put all these issues under one umbrella of labor legislation. So identified different areas. The government of India designed different labor acts concerned to the particular subject matter. So here it will be five classification in that. It is basing on the working conditions, basing on the wages, legislation on social security, legislation on employment and training, legislation on industrial relations. So let us see what comes under these labor laws. Under the labor laws, under the legislation on working conditions, Factories Act 1948. So this is most important act which will be designed in the year 1948. See, in the earlier concepts also I specified, I focused. Factories Act is the base for all other acts also. So where in the Factories Act, where five important provisions will be there, that is health, safety, working conditions, hours of work, and annual leave with wages. These five important provisions are discussed in the Factories Act. The work, especially they specified where the labor is working in the factories, labor is working in the plantations, labor you can find in the mines, labor you can find in the motor transport, labor you can find the contract labor, labor you can find in the AP shops, suppose the shops and establishments. These are some of the sectors where you can find number of labor the employer will engage for that. So identified the importance of the labor who are there working in the different working conditions. These legislations are made. That is labor legislation on working conditions. Suppose if you see plantation, so where these plantation labor will work in different. Especially in the especially in the hilly areas, plantations means if you say tea plantation, rubber plantation, coffee plantation, teak plantation, where these in different weather conditions, different conditions, these labor will work. So, basing on their working conditions, it is the duty of the employer to provide different facilities to the labor. Suppose if you see mines, in the mines where above the mine and below the mine, that is above the ground and below the ground. Above the ground, say you can give the normal working conditions, but people, the labor who are working in below the ground, that is underground, which is very dangerous to the life of the workers. So they have the different working conditions, so that they have different provisions. Suppose where you will work 8 hours per day by taking an half an hour rest, but in the mines continuously you can work only 2 hours. About after completion of 2 hours, you come out from the mine. That 2 hours is very hard. That 2 hours are very risky. That 2 hours are very difficult, which is a danger to the life of the particular labor. So that is the Mines Act is there. Where you can find the motor transport people who are working very hard. We can see in the roads and the other areas where the labor is working with the dangerous chemicals, oils with that. So that is the one of the labor you can find. And sometimes shops and establishments. You can see the persons, you can see the employees or the labor where the shops and establishments are working in the society, and that also it is the duty in the different working conditions. So some people are working in high level, that is 10 to 50 feet of the above the ground. So 10 to 50 feet high. So you can find that the risky of their life. So that is also one of the protecting their working life from the working conditions. Coming to the next concept is legislation on wages. So earlier we discussed about these laws. That is the duty. It is the duty of the employer to provide the wage and salary to the employees. So if he makes any mistakes, the law is there to protect his payment of wages by way of payment of wages, by way of minimum wages, payment of bonus, and equal remuneration. This is also we discussed, that is payment of wages, proper wage you should pay in a fixed time. Suppose say if you want to pay every month first, you should pay every month fifth, you should pay every month 10th, you should pay, but should not cross the 10th. And also you are prohibited, that is employer is prohibited to deduct the unauthorized deductions. So minimum wage. So irrespective of the scale of pay or any other basic pay or any other, it is the duty of the employer to pay the minimum wage to all their employees to meet their necessities, basic needs, that is food, shelter, and clothes. Suppose in the present situation, present conditions, if you pay, that is the employer may pay 5,000 rupees or 3,000 rupees to a labor, is it good to maintain himself and the family of the particular labor? With the 3,000 rupees, we cannot maintain, even though the government support by way of different schemes. But it is the duty of the employer to pay the minimum wage, what designed by the central government, basing on the cost of living, and also prohibited by showing the gender discrimination between male and female, that is where Equal Remuneration Act is made in the year 1976, which is equal pay for equal work, similar pay for similar work. Third one is legislation on social security. Okay, once you are providing the salary, wage, and etc. bonus to all your employees, the social security says anything happens, that is any health or injury happens to the worker, who will protect? So it is the duty of the employer to protect the employee basing on these acts, that is Employee Compensation Act, where any employee met with an accident and maybe a death may be occurred or there may be an injury. The injury may be a disability. So it is the duty of the employer to pay some amount to the deceased of the family or the injured work employee. That is in the Employee Compensation Act. Another one is Social Security is Employee State Insurance Act. So we earlier discussed in the historical development of labor laws. This is one of important scheme, that is where an employee contribute to the from his or her salary. The insurance will be there to himself and as well as his or her family members. Any medical assistance, any medical problem arise, that insurance will be covered. And the Provident Fund and Miscellaneous Provision Act, where basic principle of this Provident Fund is making a habit of savings. That is the simple one. Making a habit of savings. Suppose if you pay 10,000 rupees to a labor or 25,000 rupees to a labor per month, without knowing, he don't know or she don't know how to save it. So that 10,000 rupees or 25,000 rupees, he or she can spend within 1 week or 10 days, and rest of the 20 days or after the retirement or any sudden things are happened by way of death or injury, he should or she should not have any money. So to making a habit of to meet that type of contingencies, the government made compulsorily employer should deduct 12% from the salary of the worker. That is Employee Provident Fund and Miscellaneous Provisions Act. That amount will be given to the employee or the worker after his or her superannuation or retirement. He will get some lump sum amount. Payment of gratuity, where by showing the gratitude towards the employee who worked in the organization maybe 30 years, 25 years, or 10 years. This is where the gratitude shown by the employer towards the employee by paying some lump sum amount to the employee. Fourth one is employment legislation on employment and training. As when we discussed about employment and training, that is any vacancies arise, it is compulsory to notify in the Employment Exchanges Act, that is Compulsory Notification Act 1959, and Apprenticeship Act. Any training is there in your organization or any organization, it is compulsory to notify in the under the Apprenticeship Act. Then the important one, that is 5, is maintaining industrial relations. There is a legislation maintaining industrial relations or Trade Unions Act, where Constitution gives a right that any 7 people can form a union. So trade unions who are there in every organization, every factory, it is nothing but they want to fulfill their demands by way of unionization. This union will fight for the benefit of the workers, their members, and as well as the employer side also. Because if the organization is not there, employees will not be there, and as well as employees are not there, organization is also not there. So the trade unions fight for their demands and also for the growth of the organization also. That is one trade unions act made in the year 1926. Another one is very important thing is Industrial Disputes Act 1947. This ID Act is gives settlement mechanism of any dispute arises in the factory or the establishment. So any dispute arise, you can we have the courts and other industrial tribunals, but this act says first of all you go and settle in a Gandhian way of collective bargaining, employee participation in the management, and as well as every organization should constitute some works committees and also grievance redressal committees. First of all, you settle your disputes, your grievances within your premises. Later on, if it is not settled, you go for other mechanisms like say arbitration, court of inquiry, industrial tribunals. So these industrial disputes give a, a mechanism, a systematic guidelines, and the disputes are arise. And this is also other side of industrial dispute is the specified the strikes, lockouts, layoffs, retrenchment, and closure. So which one is a legal strike, which one is a legal layoff, legal lockout, and which one is illegal strike, and which one is illegal lockout. That is explained in the industrial disputes, and as well as layoff. Yes, employer can lay off some of his unit or entire his factory, but all of a sudden if gives the layoffs, he has to pay the some layoff elements. That guidelines explained in the layoff concept. Suppose if the organization wants to remove the surplus employees or the workers, that retrench the employees or the workers. In that also, they have no right to declare or announce immediately that is from tomorrow onwards these people are not necessary to come to the factory. So there is a procedure to declare or retrench some of the employees, terminate their services. There should be a procedure that is also explained in the industrial disputes. And you should not all of a sudden close your factory. If you want to close your factory, certain procedure is there. That procedure you have to follow, giving notification, intimation to the concerned governments and the labor unions and other authorities. After that only you have to close your unit. That is closure will be explained in the industrial disputes. Industrial Employment Standing Orders Act 1946. This is very important to prevent the industrial disputes. So these industrial standing orders are nothing but a certain standing orders are designed by model standing orders designed by every organization with the consent of their trade unions. So this standing orders nothing but set of rules and regulations bound by the labor. Because if there is no certain rules and regulations, like when the shift starts, if the timings are not specified, the worker may come at 8 o'clock or may not come at 8 o'clock because there is no specified time mentioned in that. And when the shift closes, that is, say, it shifts closes 4 o'clock or 5 o'clock or 6 o'clock in the evening. If you are not specified, if the employer not specified, the worker may close his work in the within 1 hour because you are not specified it. Same as to whom you will approach, to whom the worker approach to the for the any leave if you want to apply. If the procedure is there, this is the procedure. Suppose If you want to apply for a leave, you have to give a leave letter officially to your immediate supervisor or the concerned head of the department. That the procedure is there. So every labor should follow that. If that procedure is not there, that standing order is not there, he will not come. Because if he say, I don't know to whom I have to give the leave letter. So that is one of the thing. Suppose how many employees are there in your organization, and what are the classification of their employees? Like say how many are permanent, how many are temporary, how many are casual workers, how many are contract workers, how many are trainees, how many are apprentices. So like that. That classification also you should maintain, mention in your standing orders. And sometimes important concept is, in case of any suspension or dismissal or any disciplinary proceedings, what is the procedure? Suppose simply if you say that you have done this mistake, so I dismissed you, I suspended you, like that, this is not, this is one called as one way. So that is unilateral way, so that is not allowed. So what is the procedure in case of any misconduct occurred in your organization by any of the worker? So there is a certain procedure. That is what, first of all you have to specify which comes under misconduct. Say disobedience of the orders of the superior comes under misbehavior. Okay, coming to the work with a drunken state, that is also a misbehavior. Suppose theft is also misbehavior. Damage to the property of the organization, that is also misbehavior. So like that you list out what are the misbehavior misconducts in the organization. So that list contained in the standing orders supplied to the trade unions and the concerned labor department. If there is no objection, the labor department approved it, and that is called as certified standing orders, and which is bound all the labor employees in the organization and as well as to the employer also. So that is nothing but Standing Orders Act 1946, mainly prevention of industrial disputes. And the next one is sexual harassment of women at workplace. This has happened in the way back in the past, but women who are not supposed to or are unable to express their grievance, any harassment, so that something maybe happens in the past. Now it is changed, where the government identified these type of activities are increased in the workplace, and as well as because women also are ready to work in the organizations. So this type of things are happening in the organizations. So this act is made in the year 2013, that is prevention, prohibition and redressal. So anything happens, it is designed some sort of mm, things which is leads to the sexual harassment. So the it is actually prevented. So should the employer should maintain some sort of particular protocols like display boards, which are comes under sexual harassment. And prohibition is nothing but is every organization it is prohibited. And if anything happens as sexual harassment comes under sexual harassment, what are the redressal to the particular injured woman employee? So that is explained in the Sexual Harassment Act 2013. Thank you.